Now I'm going to turn to two major developments in two very high-profile legal cases. We're going to begin with today's massive 3 million-page Jeffrey Epstein document dump by the Justice Department. Now, the DOJ says it has collected roughly 6 million pages of records in response to the Epstein Files Transparency Act. A way to think about that, if the pages were all stacked on top of each other, it would be the equivalent of 2 Eiffel Towers. Now, today's drop also includes more than 2,000 videos and about 180,000 images that are all related to the Epstein case. The question is, what's in all this? What's in the latest release? Well, a lot of it comes from long-standing investigations into Epstein and his associate Ghislaine Maxwell. It spans cases in Florida and New York and multiple FBI inquiries. There are search warrants, court records, email correspondence, flight logs, photos of his homes, travel details, Maxwell's arrest documents. There's also various law enforcement reports on interviews and evidence collection. And yes, the files do include multiple mentions of high-profile public figures, though officials do stress just being named does not imply wrongdoing or criminal conduct, or even knowledge of what Epstein was up to. Now, the images and videos have heavy redactions to protect victim privacy or exclude materials that could be illegal, to distribute to the public. And Deputy Attorney General Todd Blanche said that the department made very significant efforts to redact only what was necessary, that nothing was withheld to, protect any specific politically exposed individual. And that means that members of Congress, if they want, they can request unredacted material if they qualify. But here's the problem. The release has drawn criticism from both sides. Some lawmakers say the heavy redactions and the delays past the original legal deadline, it raises doubts about whether the public really got everything that exists. Others say victim privacy and safety has to come first. And was that exposed a little bit too much today? Now, it should be noted, several victims said they were frustrated by the heavy redactions in the photos and documents. And even now, there are reports of emails and interactions that show pictures and notes and suggest connections between Epstein and powerful figures, but those don't necessarily amount to evidence of criminal conduct. And there's also, by the way, you move from that case to another big development on Friday. This might have been the headliner. Big news in the Luigi Mangione case. A federal judge ruled today that Mangione will not face the death penalty in the 2024 killing of United Healthcare CEO Brian Thompson. In fact, the judge dismissed the federal murder and firearm charges that would have made capital punishment possible, finding that they were legally incompatible with the federal stalking charges, that those two charges actually remain in the case. So there's only stalking left. Basically, the prosecution needed to show that a murder was committed during the course of committing a crime of violence. And prosecutors said, hey, that was stalking. The judge found under the law, under the specific legal definitions, stalking is not actually a crime of violence. I know that might not make sense on the face of it, especially given what we're talking about in this case. Even the judge acknowledged that, and we're going to talk about it. So yes, Mangione still faces 2 federal stalking counts. That could carry up to life in prison, by the way, if he's convicted. And he also faces a separate state murder charge in New York. Now, this is a win. Okay, this is a win for him, but there was a win for the prosecution today because the judge also ruled that evidence that was seized from Mangione's backpack at the time of his arrest, including the alleged weapon and writings, admissible in court. The jury selection for the federal trial is set to begin in September with opening statements in October. So that is a lot of new information, but I got a great guest to help me sort it all out. Trial attorney Mark Geragos, thank you so much for coming on. Really appreciate it. Let's start with Epstein, okay? Because when I look at the Epstein case, I'm trying to make sense of what were the big takeaways today and what we've learned. What's your takeaway from it?
Well, my takeaway is there's quite a bit of information that I think people have suspected, and now they've got proof of it. I heard the introduction, and I would just tell you, as somebody who's done a fair share of federal criminal work, these redactions are not unusual. Sometimes when I get discovery, the government has redacted whole pages and repeatedly whole pages. So this is not surprising to me. I agree with everybody who's bitching and moaning about it, so to speak. But the fact remains is this is what they do. Generally, they err on the side of caution when it comes to victims, which I know some of the victims are frustrated by. But if you don't do it in this wholesale fashion, a lot of times you can leave out, and I've had this happen more times than I can count. If they don't err on the side of redaction, it's pretty easy to figure out what was redacted. And so that's
there are some people who came out today that the names were exposed, that the victims' names were exposed, and they were upset about that too. But then on the flip side of it, just to jump on what you said, people are saying, okay, do we have now a sense of everybody else that was a part of it? There was a part in this release where you had draft indictments from the early 2000s. So there was potentially other people that were going to be indicted, co-conspirators. We don't know who those people are. Did you get any sense from these documents today that who else might allegedly be involved?
Yes, I actually did. I don't want to repeat it, but I'll tell you there's at least 3 different people who, if you connect the dots, you can see who it was they were looking at. Draft indictments, to my mind, should never see the light of day. I think that is what's called work product. I will tell you, 30 years ago, they had a draft indictment, the Whitewater Council did, of Hillary Clinton, and it was only in trial when I was cross-examining one of the special counsel that we found that out. It's frankly outrageous that draft indictments are released or even talked about. I think those things you have no way to defend against it if you're somebody who's in the crosshairs. It was never filed. It's patently unfair.
And privilege was one of the reasons they could actually redact certain information. I did have to ask you, when we're talking about work product, there was a list compiled by the FBI of what was determined to be unsubstantiated tips regarding the president. That was the headlines today about allegations. People came in against Donald Trump. It was sent in an email. Why was the FBI making a list? I mean, why was that in a list? I was confused by that.
Well, anybody who's done anything with high-profile cases or has defended or associates with high-profile figures, unfortunately, part of what comes along with that is you get the crazies. You get people who are unhinged. Who I get emails every day, and there are certain telltale signs, and you, I'm sure, get them as well. And why would you kind of regurgitate that and give it any kind of credence?
Fair enough. I want to go to Mangione while we have the time. Do you agree with the judge's decision to throw out this murder charge? And I have to imagine the government is going to appeal this because they want that on the table. They may want the death penalty on the table. So do you agree with the judge, and you think they have a likelihood of success on appeal?
I do, and kudos to Jacob Kaplan and Karen Agnifilo, who did a magnificent job here. And actually, they've had win after win in their defense of Luigi, and it's really, I think the judge did do the right thing here. I thought the judge previously on the state side did the right thing. This is what happens when you get one of these, what I call prosecutorial pile-ons or a prosecutorial dog pile. They go over the top, and that's what a good, robust judiciary does. They stand between an out-of-control DOJ or an out-of-control prosecutor, and that's why you need good defense lawyers to stand there and try and say, you've gone too far, and that's exactly what happened here.
I thought it was interesting. The judge said, I know people reading this might not make sense, how stalking is not a crime of violence when you're talking about a guy who allegedly killed the CEO on the streets of New York City. But one of the arguments was, if you look plainly at the definition, right, stalking can mean somebody that engages in self-harm. And if you have that broad definition of what stalking is, maybe it's not necessarily a crime of violence. I thought it was really interesting. We'll see if they appeal it. We'll see if they're successful. Mark Geragos, thank you so much. Have a great weekend.
Good to see you. Thank you.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.